This meeting is being recorded.
Okay, that's interesting. It gave me 2 recording messages. This is being extra recorded.
All right.
All right, well, good afternoon, everyone. My name is Alexis Alvarez. I'm the Director of Statewide Training at Florida Legal Services. We're here today for Fair Housing, everything you need to know about disability rights and emotional support animals, but we're afraid to ask. Folks may see I have my unofficial emotional support animal here with me. Unfortunately, I couldn't get past the legal channels to see if he could be my emotional support animal. But I love him, and I thought it was a good excuse for me to bring him on camera and say hi to everybody. So with that said, I will put him to the side and get ready to introduce you to today's speakers and today's content. So as always, our housekeeping, this was approved for CLE credit. It was approved for 1 general CLE credit. I know folks are really interested in those bias elimination, and this really should have been accredited for that. This one isn't, but the next one will be. And at the end of our session today, I'll give you the information for our final installment of this Fair Housing training series with that training opportunity to get some bias credits. So with the CLE credit for this course, hang tight. At the end, I'll drop it into the chat, and I will also announce that code out loud. This is also being recorded, as always. You will receive a copy of this recording in an email from Zoom within 24 hours after this event. Of course, if you don't get that in your inbox, I'll drop my email into the chat. And if you reach out to me and say, hey, I didn't see the email in my inbox, I will be happy to personally send that to you. Questions and answers. For folks who have already been here through the training series, you know Joe and Christina, they are awesome at monitoring that chat, monitoring that Q&A, and really answering your questions as they come up or when they can. So please don't be shy. I know the chat may be disabled right now. I'll turn it on in a second, but don't be shy. Put your questions into the chat, put your questions into the Q&A. I can absolutely guarantee they will be answered because Joe and Christina are awesome. Last little bit of housekeeping is don't be shy, participate. We want to hear, what you're experiencing, what you're going through, and want to make a conversation with you when we can, because, this topic is important and very multifaceted. So don't be shy. Let us know your thoughts when you're thinking them. So with all that said, I'm going to move right into introductions. So for those of you who have already been here for a few of our trainings in this training series, the Fair Housing training series, I have to admit, I still have not memorized these bios, even though I've now read them 3 times. So bear with me as I read them to you one more time. First, we have Joseph Cordova. He is an attorney and the Fair Housing Manager at Florida Legal Services. Joe spent the first 2 years of his legal career as an Equal Works Justice Fellow, practicing community lawyering for immigrant families. He has since then transitioned such efforts into housing discrimination enforcement and outreach. He has a bachelor's degree from DePaul University, a Master's of Arts from the University of Colorado in Public Policy, and a Juris Doctor from the University of Florida, Levin College of Law. Joe has over a decade's experience working with vulnerable populations, performing community development services, and was recognized by the Levin College of Law with the 2018 Helen Gibble Bleachman Memorial Community Service Award. We also have with us today Christina Benitez, and Christina is the Fair Housing Outreach Coordinator at Florida Legal Services. Christina is a graduate of Ohio State University. Over the past decade, Christina has worked in a variety of professional capacities, both in the private and public sector. Christina has experience serving vulnerable populations through her extensive volunteer work in the community. Her work focuses on providing support for the Fair Housing Project by conducting fair housing outreach and education in North Central Florida. So without further ado, I'm going to enable the chat. I'm going to turn it over to Joe and Christina. Joe, Christina, thank you not only for being here today, but for this awesome training series that we've had going on. We're really looking forward to learning from you today.
Thank you so much for having us. Hello again, everybody. I was just taking a quick look at the participant list. I see some familiar names. I also see some new names. So as we get started, we're just going to do a very, very short brief recap of some of the stuff we've talked about in the weeks or the months past, but we really are going to dive into disability-based rights and emotional support and service animals today. So I'm going to pass it over to Christina and let her kick things off. So without further ado, Christina, please go ahead.
So these are some of the topics that we're going to discuss today. What is disability under the Fair Housing Act? What is discrimination in housing on the basis of disability? What is reasonable modification? What is reasonable accommodation? And what are the two types of assistance animals? And before we continue, I just want to make sure, can everyone hear me well?
Yeah.
Yes, okay, great. Well, okay, thank you, Joe.
Yeah.
So yes, we're gonna start off by just doing a very quick review of the Fair Housing Act. Yeah, thank you, Edward, thank you. And a very quick review of the Fair Housing Act and its protections. So as we can see, the Federal Fair Housing Act prohibits discrimination in housing-related transactions because of a person's, remember the 7 protected classes. And I think, Joe, if you, yes, we'll look at the 7 protected classes: race, color, religion, national origin, disability, sex, family status, and and family status. I named all 7. There we go. So here are the 7 protected classes. As you can see, disability was actually added to the Act in 1988.
And real quick, before we jump to the next slide, we just want to remind everyone, when we talk about the Fair Housing Act, most of the time we're talking about the Federal Fair Housing Act. So wherever you're at in the United States of America, this applies. But I want to point that out specifically for today, because later on we do have a slide that's going to focus on the Florida Fair Housing Act and a kind of a hot button issue that keeps coming up in the state of Florida. It really is coming up across the country, but it seems to be, let's see, more enumeratedly responded to at the state level. And we'll talk about that a little bit later on. Okay, so I will talk to you. So what is a disability under the Fair Housing Act? So if a disability is a physical or mental impairment, such as diseases, drug addiction will count. We'll come back to that here in just a sec. It is an impairment that substantially limits one or more of a person's major life activities. Record of an impairment or being perceived as having a disability. So let me go back up to the top there. So it's a physical or mental impairment. It means that it does not always have to be readily apparent. So even if you cannot see it, it does not matter. If you have the disability because it is an impairment, it counts as a disability under the Federal Fair Housing Act. So certain diseases will qualify. And then just to specify, substance addiction is qualified under the Federal Fair Housing Act as a disability. Current use is not. So if your addiction is behind you, or at least you're working on it, you are going to meetings, you're going to therapy, you're taking medication, whatever it is you're doing in your life to say, this is behind me and I'm working on it, your previous addiction, your current life status qualifies as a disability under the Federal Fair Housing Act. But currently being an addict is not, okay? Now, where the line is drawn between relapse and a non-relapse, I'm 60 days sober, I'm 90 days sober, I relapsed last week, but I'm back, 7 days sober, case by case, okay? Everything is going to be case by case. But the idea is that looking back on addiction, working on yourself now is going to be considered a disease or a disability. But coming home drunk one night and then saying I have a disability, I'm drunk, that's not what the Federal Fair Housing Act covers. We talk about an impairment that substantially limits one or more person's major life activities. Sometimes we hear that word major life activity and we think it has to be impacting only the biggest things about life. Honestly, I would say the person's major life activities is better defined as simple life activities. So breathing, eating, sleeping, working, walking, the things that we get up in the morning and imagine ourselves just being able to do so that we can function and enjoy our lives equal to everybody else, those are our major life activities. So any sort of impairment that substantially limits that qualifies as a disability. Now, I like to give this example now and then. Let's say I think it's 20 years ago and I'm back in my youth and I go to try to dunk a basketball and I fail miserably and I land and I sprain my ankle. And then the next day I go look for housing and I'm limping, or maybe I'm using crutches, or maybe it's such a bad sprain or tear that I'm in a wheelchair. And the landlord looks at me and says, sorry, we don't rent to you. Now, some of you might say, well, Joe doesn't have a disability. He hurt his ankle. It will heal, and in a few weeks he'll be up and everything will be, somewhat back to normal. But because I was regarded as having the disability, the landlord took one look at me and said, no, not for this guy, because we don't have ramps for his wheelchair. That still counts as me being regarded as having a disability, even though I probably don't have the impairment that substantially limits a major life activity longer than a week or two until I heal. So again, it's going to be case by case. The individual themselves might not identify as having a disability, but they're being regarded as such. And then this also includes the record of an impairment, okay? I used to have a particular disease, it's in remission, or I've healed, but it can come back kind of a thing. Landlords aren't allowed to look in your past and say, because you had it before, you're probably going to have it again. Therefore, we're going to say no to you. Okay. So really anything that has a fingerprint of your disability where the landlord is using it against you is going to be protected. And then we did have a note here in the chat box. Oh, that was from Christina. Yes. Learning, working with your hands and function that include taking care of yourself. Yes. Thank you. Includes taking care of yourself. So anything that prevents you from living independently and enjoying that independent lifestyle is going to qualify as a disability. Okay, so when we talk about unlawful practices in relationship to housing and disability-based discrimination, we're talking about anytime you deny housing to a person with disability. So if you are in a position that basically you can put up the stop sign that tells someone, I am not going to let you live here because I refuse to give you a mortgage, or I refuse to sign a lease with you, or I refuse to give you access to the unit because of your disability. I'm the one who has the stop sign, so I'm denying you housing. I'm discriminating against a person associated with a person with a disability. So someone in your household has a disability, and I'm using that against you. Your name is on the lease. You're signing all the paperwork, but you also take care of your mother, and your mother has a disability. And I'm going to say no to you because of her. The whole household is protected. I'm denying you access to the recreation facilities, parking privileges, and other services offered to all tenants. So common spaces, community spaces. If I say everybody gets to enjoy this, but we're not going to install something in our swimming pool to allow you to enjoy it, that's denying you the full access to your housing. Let's say we say, and maybe I say this because I think I'm doing you a favor, and I say, oh yeah, no, fine. Everyone who has a disability, they all live on the first floor. We do that because it's very convenient for them, everything like that. Okay, maybe you are making it convenient, but over time, are you segregating people with disabilities to the first floor? What if you have a place that has an elevator anyways? Is it necessary to put everyone with a disability on the first floor? Sometimes it is mitigating the situation. Sometimes it is saying, yes, and I'm accommodating your disability. But sometimes it could be considered segregating people with disabilities to certain areas of the housing complex. So case by case, if someone came to me with a story saying, my landlord said I can live here, but I have to live on the first floor, we might dive into the details of that and be able to come back and say, it sounds like your landlord is actually trying to make it so you can live there. So this would not be discrimination. But a same story, different details might come back and say, sounds like they are discriminating. And then anytime you deny someone a reasonable modification or accommodation based on their disability, and we're going to get more into the details of what those are here in a second, that's another unlawful practice. Really what it comes down to is anytime you are denying somebody with a disability their equal enjoyment of housing, it's going to probably be a violation of the Fair Housing Act. So I'll pass this on to Christina. We'll do a quick scenario here for you.
Yes, a quick example. So we're going to look at an example of an association with a person with a disability. It says, Tom and Sarah are a married couple that are looking for housing. Sarah has a walking impairment and uses a wheelchair. One day, Tom goes to check out a rental on his own because Sarah wasn't feeling too well. The visit at the rental site was going very well. The landlord showed Tom the available unit and invited Tom to fill out an application. When Tom told the landlord they could have when Tom told the landlord if they could have an assigned parking space for his wife because of her disability, the landlord said they could not provide an assigned parking space and the unit was not appropriate for people with disabilities. So
Go ahead.
I was just going to invite everyone to participate and tell us what's wrong with this scenario. Or Joe, go ahead if you wanted to add.
That's exactly what I was
else.
going to say. So we'll do some issue spotting. Let's pick this apart. What's wrong in this scenario? What should have been done? What was wrong, done incorrectly? And feel free to jump in the chat box and let us know what you think.
And then, is Tom protected even though he doesn't have the disability?
So we see, and not making a reasonable accommodation. Okay. Tom would be protected as part of the household, right? Yes, that is
Yes.
correct. What else do we see that's wrong in this scenario? Okay, yeah, Tom is protected. Yeah.
Exactly. Tom is protected because his wife, Sarah, has the disability.
Okay, perfect. Yes, everyone's right. Everyone's hitting it. I want to point out this last one from Courtney, no assigned parking spot. A lot of times you're going to hear landlords tell people saying we have plenty of handicap parking. Okay, well, the handicap parking that you have is not close enough to my unit. It's still an accommodation request and it's valid. It's a reasonable accommodation request saying, if I could get a parking space for me reserved so that I can access my unit equal to the way everyone else accesses their unit, that would be great. Okay, and denying that would still count. A lot of times landlords will try to say, we've already planned for this. Okay, well, you can't already plan for someone you've never met. Okay, you can do your best, you can prepare a unit, you can make sure that it's ADA accessible, you can do everything you can, but until you actually meet the person and you hear their request, you have to answer it on a case-by-case basis. All right, terrific. So let's move on. Let's talk now about reasonable modifications, okay? A reasonable modification, it's a change made in housing structures. So physical change to the units, inside the units, or in the common spaces, to the exterior, interior, or those common areas. Now, the tenant must obtain the landlord's approval before making the modification. So you can see these pictures here. We have a gentleman in a wheelchair washing his dishes. It looks to me like what the modification there is that the countertops were lowered, okay? We see grab bars in the bathroom, and then we see a ramp for someone in a wheelchair. These are all physical modifications to a structure. Now, like we said, the tenant has to obtain landlord's approval before making the modification if that modification really alters the structure, okay? If inside their unit, they just have a couple things like, I don't know, like putting some rubber bands on the doorknob, so arthritis, it's easier to turn the doorknob. I don't think you need approval, you know, for something small like that. But as far as anything that's really going to change the structure of the unit, that needs to be approved first. Now, the person with a disability, if this is in private housing, the person with the disability, they pay for the cost of the modification. They can be asked to pay for it. So a landlord can say, sure, yeah, you can install grab bars in your bathroom, but you have to pay for it if it's private housing. If it's federally funded housing, then the housing authority or whatever the subsidized program is, they have to pay for it, okay? Now, at the end of private housing, the landlord can say, okay, you added grab bars to the bathrooms, you paid for it, now I need to ask you to pay for it to put it back the way it was upon your vacancy. One thing to keep in mind there, though, is that it needs to be recognized as, is it reasonable to ask them to undo the work that they did? A lot of times landlords might say, I need you to take the grab bars out of the bathrooms out of spite. But grab bars are a helpful part of any unit. Okay, you've increased the value if you've added grab bars to a bathroom. So sometimes you can, offer to the landlord, I'm actually going to, as a favor to you, leave it there. This helps your future tenants. Okay. And then one thing, the big thing to remember with reasonable modifications is that the landlord may deny requests that are unreasonable or results in an undue burden. So let's unpack those two words. Unreasonable. Is it reasonable to ask for grab bars in a bathroom? Absolutely. Is it reasonable to ask for a ramp for someone who lives on the 7th floor? I don't know what that ramp would look like. That might be unreasonable. It would be too steep. I don't know what that would be. Okay. So is the request reasonable? Can it be done? Can it be done without altering the structure of the building too much? If you have an old building that maybe has 6 units total, 3 floors, 2 units on each floor, and they ask for an elevator to be installed, that seems like that's going to be unreasonable. And even if the tenant says, I'll pay for it, the landlord is able to say, no, that's going to knock out half my building. Okay, is it reasonable? Now, you might be asking yourself, well, what's reasonable to one person might not be reasonable to another. Very true. So it's case by case, and sometimes we rely on case law to decide what was reasonable for them may be analogous to reasonable for you. Okay. When we give these presentations to housing providers, we always encourage them to err on the side of saying yes. Okay. Even if the part of you thinks it might be unreasonable, if you can stomach the amount of unreasonableness, then say yes. Okay. It's better for you in the long run. Then that second term we need to unpack is undue burden. Okay. There's 3 kinds of undue burdens. One we just talked about is a burden on the structural makeup of the building. Okay, this building's too old, we can't add this stuff, the building will crumble, or something like that. Once you get the ADA involved, you're probably going to have a situation that says this building probably shouldn't be standing anyways. But you get what I'm saying. If it's an undue burden to the structure, the landlord can say no. If it's undue financial burden, landlords can say no. But again, in private housing, tenants are expected to pay for it. So landlords cannot use that as an excuse in private housing if they're saying, no, it's going to cost too much. Well, I'm paying for it anyways as the tenant. Oh, I can't really use that excuse, can I? And then the third type of burden is an administrative burden. If it's just going to be too much administrative work, and this usually has more to do with reasonable accommodations, which is what we're going to talk about next. But if there's too much administrative work that now, their part-time office staff is now having to work full-time simply because this one individual has this additional stuff going on in their tenancy, you might be able to qualify that as an undue burden. All right, so we'll give you another example here.
Okay, another example. It says, John, a person with a disability who uses a wheelchair, views a condominium he is hoping to purchase in a new multi-story building. When John arrives, he finds there are no accessible parking spaces in the building's parking lot. When John tries to enter the unit, his wheelchair can barely fit through the door, and he bangs his arms on the way in. Inside the unit, the thermostat and light switches are all too high for him to reach. The building has a fitness room, but he cannot look at it because the only way to get to the fitness room is to go up the stairs. So what are some issues we see with this example?
And when you think of your response and type in the chat box, try to think, is he protected yet? Remember, he's just looking for a place to live.
Mm-hmm.
Does he qualify for protections? So he hasn't purchased it yet.
Mm-hmm.
What else do we think? Can any of these be considered reasonable accommodation? Okay. So John is a person who's looking to see if he wants to live there, but he really can't even see anything because it's not, go ahead, Christina.
Oh, I was just going to say, but I didn't want to speak over you. I just thought about it. I think the question is, will everything that he see is not accessible to him, will that have an influence on his decision to purchase this condo? Sorry, Joe.
No, that's exactly right. That's exactly what I was going to say. You said it better. The idea is that he's constructively being denied housing because he can't even look at it to decide if he wants it in the first place. And it's not just John. Anybody in a wheelchair who wants to live in that condo community isn't going to live there because they're not going to purchase something sight unseen, because they can't see it, because they can't actually maneuver their way through the community.
Mhm.
So at the end of the year, if they did some research and said, how many new condo owners live in your community? 0 of them are going to be people who have disabilities similar to John's. Not only is that direct discrimination against John, who is physically there trying to see it, but you can make the argument that that's disparate impact. People with disabilities are not welcome in this community because they can't even see it in the first place to see it. Well, then the next question is, if I'm the condo association, I say, well, wait a sec, do we have to fix everything for potential tenants or potential residents? These folks don't even live here anymore. Okay, or they don't live here in the first place. They never moved here. So why do we have to fix things for people who don't live here? Again, we err on the side of, yeah, you make a good point, but it's probably best to install a ramp. It's probably best to prepare this condo community so that everybody has an equal access to eventually move in one day. Not to mention, let's say you figure out a way to get John to simply have an uncomfortable visit that day. He's out of his wheelchair. Maybe he can walk a little bit, but he has to stop every now and then and lean against, a pole. Maybe he has a family member that he can kind of lean on. He's not really getting to view the condo in any kind of comfortable manner. So he's likely going to say, no, I don't want to live here because it was an uncomfortable experience. Okay. If you go through all the different scenarios of what John's experience was, it's gonna result in discrimination. So the advice to the condo association here is, go ahead and make the changes, do what you need to do. If it's an undue burden or anything like that, you can always, justify certain decisions based on that. But it's best to make this open to everybody. Please.
And Joe, may I ask, going back to this example, because someone pointed out reasonable accommodation. So if he hasn't purchased the condo yet, can he say what's wrong with it to the seller and say, well, I would like for you to make some changes, or is that only during his, I guess, once he purchases the condo, can he make such requests?
So that's a great question. So if it's on the inside of the home that he's buying, okay, he buys a condo and it's on the inside, he can negotiate with the seller. Hey, I'll buy this from you if you do the following things. And the seller can say, no, you're the future homeowner. That's going to come down to a negotiation of, who the seller and the buyer. As far as the condo association goes for those community spaces, he does have a right to tell them and say, look, the reason why I've chosen not to live here is that you have not made this place accessible to people with disabilities. So I'm giving you guys a heads up. You're probably going to get other complaints from home seekers like myself. So you always have the right to let them know. Does the condo association have to act? It's probably in their best interest because, like we mentioned before, if it's disparate impact and now you have 15 people in wheelchairs going to a condo association meeting saying we'd love to live here, but you won't let us, that's a much bigger problem on their hands. And so similarly, what Edward's asking, even the doorway. So expanding doorways is going to be a structural issue. If in common spaces, my guess is that the ADA might even, take a peek at this, the Americans with Disabilities Act. They might take a look at those doorways and say, this is not just a disability issue, but I'm going to get the fire department down here too, because this is a safety issue. If you have so many people living in a particular area and they can't access the doorways, get in or out, it's safety, it's discrimination against people with disabilities, and so on and so forth. So my guess is that condo association is going to have to revisit whether or not they're grandfathered in to keep their doorways the way they are, or if they need to go ahead and hire a construction crew to come around and make them not only ADA accessible, but more welcoming to people with disabilities. So case by case, I'm sure there's plenty of places throughout this country that is able to kind of say, we didn't have to do our doorways because certain building codes, certain, dates of construction and stuff like that. But I think as the years go on, more and more home properties are basically having to change those doorways, expand the hallways and stuff like that. Yeah.
And just for clarification, this would be an example of a denial of housing. So even though they're not directly saying
Yeah.
you're not welcome here because of your disability, it's still a denial because it's not accessible.
Exactly.
Yeah.
Exactly. Yeah. They did everything in their power to not welcome him in. That's a denial. So let's talk about reasonable accommodations. Okay. What's an accommodation is a change made to a rule, a policy, a practice, or a service. Okay. It's not telling someone you no longer have to follow the rules. It's basically saying we're going to expand room in the rule or the policy or the practice so that you can enjoy housing equal to everybody else. Okay. Similar as before, you can deny it if it's going to impose an undue financial or administrative burden. But if you are going to say, yes, I will accommodate your request, you can't say as long as you pay an extra fee or I'll increase the deposit. So if someone says, I would like a reserved handicap parking space just for me, the landlord can't say, sure, no problem, it's extra $100 a month. That's not a reasonable accommodation. That's selling them something, okay? Now, landlords are allowed to ask for certain information just to make sure that the accommodation request that's being asked has a nexus with the actual disability. So if your disability is that, let's say you don't have use of your legs, you are in a wheelchair, okay? And you say, because of my paralysis in my legs, can I pay my rent 2 weeks late every month? Well, what's the nexus? What's the connection there? Why is your late rent related to your disability? You might be able to make the connection, you might be able to connect those dots, but the landlord is allowed to ask for you to connect those dots. But can they ask for full medical records and do the review themselves? No, they're really not supposed to, okay? They're not doctors, they're not judges, they're landlords, they're property managers, okay? If you ask for a reasonable accommodation and it is reasonable and there is a nexus to your disability and you provide enough information, that should be enough. Okay. Landlords aren't supposed to say, well, go ahead and give me all your medical records and I'll review everything and then I'll make the decision. That's a poor practice. And if you hear stories of landlords and property managers doing that, that's a red flag for me. Okay. So let's look at this next scenario.
Meet Jane. Jane has a developmental disability that affects her capacity to manage her own finances. Jane tells her building manager that her mother will be paying her rent for this reason and asks if all notices relating to her rent can be sent to her mother. The building manager tells Jane that the management company has a policy of only sending notices to residents, no exceptions. Several months later, Jane receives an eviction notice because her mother had not known that Jane's rent had been increased.
Right. What do we see here? What are the issues here?
What are the issues?
And also try to think of this through the lens of the property manager. If you're a housing provider, how do you respond to this?
Right, yes. So
Okay.
failure to make an accommodation. That is correct.
Jane's mother notified them in advance, so this was reasonable. Yes, plus he wants his rent. I like that point. Yeah, if I'm a landlord, it sounds like I'm being picky. I should just be running my business. And my business is to receive rent for the units I rent out. And if receiving rent on behalf of Jane comes from mom and mom is the person I want to communicate with, we can make this accommodation because that's how I'm going to get paid. A lot of times landlords will try to say, I don't want to do this, so I'm going to put the burden back on you. You want to get paid though, right? So let's share that burden. Let's figure out a way to do this together. How about you offer me this accommodation and rent will be there on time every month, okay? But let's ask, what if the building manager tries to say, well, we have a policy that we can only send notices to rent. All right, I know that we have a lot of attorneys on the call today. is there such thing as a property manager tenant privilege or confidentiality? I know there's attorney-client confidentiality, there's doctor-patient, there's religious, priest, congregate. Yeah, I wish, no, yeah, I've never heard of landlord-tenant confidentiality. And if you signed a lease that says our business is our business and I won't share, I mean, I'm sure that landlords definitely have a rule to say, I'm not supposed to tell strangers who lives in this unit, everything like that, sure. But if Jane is saying, please contact my mother, Jane's the one who's saying, even if there was a confidentiality agreement, I'm asking you to reach out to this other person. So that policy doesn't seem to be like someone that the property manager would be able to stand behind. Real quick, I want to go ahead.
Oh no, go ahead. I was just going to say that if we can answer the question, would this be an undue financial or administrative burden?
Okay, yeah, great question. So is it an additional burden? Yeah, because now they have to reach out to someone else. But if you actually sit down and look at it, you're either connecting with Jane or you're connecting to the mother. Is that undue burden? Is that really something that the weight of the world is now on the shoulders of the landlord? No, it's just that instead of texting Jane, I text the mom. And once you put that, practice into play, you don't even know you're doing it anymore. So the property manager might try to say, hey, we have a policy. If I'm doing this for you, I got to do this for everyone. Well, not everyone is asking for a disability-based accommodation. And the law says you need to do it. And it's really not that much of a burden. So yeah, great question. And real quick, earlier, back to the scenario where John in the wheelchair was looking for the condo association, we did have a question in the Q&A box. What is the advice to John giving time issues for the sale of that condo? Understand the advice to the condo association. I don't have a specific direct answer, but I like the question because one of the things we always remind clients and people that come to us for fair housing based complaints and issues, the Fair Housing Act is a process, it's a marathon. So it's not that it's rare, but it's just more common that by the time we reach justice in a fair housing case, you may have moved on with your life. John may have bought a condo somewhere else. John might be living somewhere else for a year or two before we actually get that condo association from the original place to come around and fix their doorways and stuff like that. So as far as a time issue goes, you can always push the pressure on the condo association and you can make it as urgent as it sounds, but the Fair Housing Act doesn't really have a quick turnaround time. Every now and then you can use it to prevent like an eviction or something like that. You can use it as a defense in an eviction, but it has a longer shelf life than I think John's willing to sit around and wait for that condo association to change their doorways. All right, so let's do this scenario now. And now we're going to dive into emotional support animals and service animals. So we're going to kick things off with this scenario here. I believe this is you, Christina, right?
Yes.
Yes.
No pets. A landlord has a no pets policy. Jose, who is deaf, requests that the landlord allows him to keep a dog in his unit. Jose explains that the dog is an assistance animal and that will alert him to several sounds, including knocks at the door, sounding of the smoke detector, telephone ringing, and cars coming into the driveway. Does Jose's assistance animal violate the pet policy?
So we haven't given you the answer yet because we haven't explained this, but any guesses?
So Courtney says no, Edward says no. I think we have.
I think it does not violate. It violates it, but reasonable accommodation can be made upon proof of its dog. Okay.
Good.
No, it's a service animal. Okay. So let's dive in. Okay. When we talk about assistance animals in relation to fair housing, they are not pets. Okay. We have to get housing providers to come around to remembering that. Assistance animals, service animals, emotional support animals, they are no longer pets. Are they animals? Yes. Are they animals that live with us in our homes? Yes. Are they pets? No. They're a prescription, okay? They're just like a doctor prescribes somebody anti-anxiety medicine, they prescribe them an emotional support animal. Just like a doctor says, we're going to fit you for a prosthetic leg so you can walk better. Same thing, we're going to prescribe a service animal so that you, a vision impaired, can walk through the city streets better with a service animal. It's a prescription. It is no longer a pet, okay? So a service animal, these are trained. They are trained and certified, okay? Service animals can be dogs or miniature horses, and they are assigned to perform a specific task. So just like Jose's dog, he's specifically trained and certified to be Jose's ears. That's a service animal. On the other side, an emotional support animal is not trained. It's there to provide therapeutic emotional support, and it can be any animal. In fact, right there, you see an emotional support alligator. That's okay. That's the support. That's the therapeutic support animal that this person has chosen. And again, it is prescribed. It comes with a doctor's letter that says, based on my analysis and diagnosis of the patient will benefit from the following prescription: having an emotional support animal. And the person themselves can go and say, this is the animal I choose because this is the one that is best for me. So it is no longer a pet, it is a prescription. And we have some chats here. Service animal must be. Landlord said no dog policy, would that change? Okay, good question. So if the landlord says we have a no dog policy, it's tricky because now we're looking at the words. Well, is the emotional support animal a dog? If it's a dog, it's still a dog, but it's not a pet, okay? My guess is that if they have a no dog policy, it's underneath their pet policy. It's linked to why you can't have dogs. And the answer is because dogs as pets, XYZ. That emotional support animal is no longer considered a pet. Therefore, it needs to be accepted as a reasonable accommodation. That's tricky though. I'm guessing you put those words specifically. It doesn't say no pet policy, it says no dog policy. I would still say, sorry, this is a prescription, okay? Technically, yes, it's a dog, but it's prescribed. So this needs to be approved. That's a good question, okay. All right, so let's look at this slide here. So proper request and approval. So when somebody goes to request and seek approval for an emotional support animal, as long as you can say, I believe you've done the following, it should be approved. So if the tenant makes a written request for an emotional support animal or service animal to be allowed in housing, and the tenant provides a signed doctor's or qualified professional's letter confirming the need for the emotional support or service animal, and the letter/request meets the nexus between the disability and the purpose of the animal, then the request should be approved. Okay, remember, we're not, as a landlord, as a housing provider, you're not supposed to play the role of a doctor or a judge. You're not supposed to take all the information and sit at home at night and, make your decision. As long as these things are checked off, you're supposed to be saying yes. Okay, it's really a no-brainer on the housing provider's side of things. They're not really making a decision. They're really just signing off that you followed all the steps. Okay. Now, one thing I want to point out, and a little bit later on, we're going to get further into a little bit Florida law, but I want to point this out right now specific to Florida law. The state of Florida has this law that says a doctor or the qualified professional needs to also confirm that they will back up this letter by serving as witness and providing testimony if this goes to litigation. A lot of doctors and a lot of qualified professionals don't want to check that box. They say no to that. They're scared away from it. That law is specifically designed to limit the number of emotional support animals that are approved. But the Federal Fair Housing Act doesn't have that rule. So if you have a housing provider step up and say, well, we denied it because the doctor didn't check off the box that said that they would show up at a court of law to confirm this, I would say, oh, I'm sorry they didn't sign that. It's too bad I'm suing you in federal court though, because the federal law doesn't say anything about that, okay? So just a heads up, you might hear that now and then. So again, some more housing provider don'ts, okay? So the housing provider should not ask for additional documentation or proof of the disability. If it is a service animal, meaning it's trained and certified, you can ask for proof of the certification. Emotional support animals, that doctor's letter, it needs to be enough. Okay, housing providers that go digging and basically saying, well, I've got your letter here, why don't you come down to my office, we're going to talk about it. No, you're digging. The letter needs to be enough. Okay, if the letter is not clear, if the letter is basically a template that they erased one person's name and put another person's name in, and now it doesn't really fit the situation, now a housing provider might have a reason to question the letter, but they're not supposed to go digging. They're not supposed to question the selection of the animal. Okay, you want an emotional support alligator? I'm not really supposed to question that. Okay, we're going to get to that here in a sec. Okay, but breed and size, if it violates a pet policy because the pet policy says no dogs over 15 pounds and your dog is 30 pounds, but it's an emotional support dog, okay, that's fine. I have the letter and you're supposed to say okay to it. Okay, that's the accommodation. You're letting me have a dog that's larger than the dogs that you let everyone else have them. That's an accommodation. You can't give them different terms and conditions for the animal. This is a big one. You can't say, fine, I'll let you have your pet, but the moment they make a mess in the hallway, you're out of here. Is that the same condition you have for other people? If my dog's 30 pounds and the policy says nothing more than 15 pounds, and the dog that's 30 pounds that I have has a one strike and you're out rule, can't do that. That's different terms and conditions. You can't disclose any details to other neighbors other than that an accommodation was made. So if other neighbors go complaining saying, they have this big dog over there, why do they get to have it and I don't? The only answer is they requested an accommodation, we approved it. You're not supposed to go into the details of what their disability is. You cannot charge a pet fee. Even if it's standard, everyone here can have a pet, but you have to pay a $100 pet fee. Mine's not a pet, it's an emotional support animal. Therefore, I don't pay the fee. Any proper request is not supposed to be denied, and you cannot evict or terminate housing based on the request in the first place. You can't say, I got this request here, it looks like I need to say yes, but rather than saying yes, I'm just going to go ahead and end your lease. No, that's you trying to pass the buck and say, I don't want to deal with the emotional support animals, so we're just going to deny you housing completely. No, you can't do that. We have a point here in the chat box. I thought the animal does not need to be certified, just trained to do a specific task if it's a service animal. Depending on the task, I'm glad you brought that up. Most service animals do need to be certified to say that they can perform that certain task. But if there's a certain task that doesn't need the certification, you're still going to have some sort of proof that you have this animal for that reason. Okay, if it doesn't come in the form of a certification, you're probably going to have some sort of papers or something to back up that this animal is going to serve this specific task. That's a good point, good question. And again, case by case basis is going to kind of build the case law as far as what courts are considering valid enough and stuff like that. That's a great point. Okay, I want to talk real quick about the telehealth. We hear this a lot in this world of fair housing and emotional support animals. Nowadays, you can hop on Zoom just like we are now. You can meet with a telehealth medical provider. They do an assessment in 20 minutes. And at the end of that 20 minutes, they provide a letter for you for an emotional support animal. It sounds shady. People don't like it. Housing providers hate it. And the normal person on the street kind of raises an eyebrow and says, well, that doesn't sound right. Under the Florida Fair Housing Act, Florida Statute 760.272B6, it specifically says that information from a healthcare practitioner as defined in section 456.001, semicolon, a telehealth provider as defined in section 456.47, or any other similarly licensed or certified practitioner or provider in good standing with his or her profession's regulatory body in another state, but only if such out-of-state practitioner has provided in-person care services to the tenant on at least one occasion. Such information is reliable if the practitioner or provider has personal knowledge of the person's disability and is acting within the scope of his or her practice to provide the supporting information. And if we follow this down to 456.47, telehealth provider defines kind of what I just described. Okay, now you can get into the weeds in this definition and talking about good standing, regulatory body in another state, only if out-of-state practitioner provided in-person care services to tenant at least one occasion. It gets a little tricky, but for the most part, this law, this statute, this language is supposed to protect people who do use telehealth medical providers. Now, because this law can be looked at and read different ways, just like every law, we are kind of depending on case law to kind of define this better for us. But as of right now, if someone uses a telehealth medical provider to provide this emotional support animal, it's supposed to be received as approved, and this is a valid request, okay? We give this presentation next year with a little bit more case law, we might have a different response, but that's where we stand right now. We have a question here. Can landlord put restrictions on your emotional support animal or restrict the emotional support animal if, for example, your emotional support dog bites another tenant? All right, ding, 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 ding. All right, we have the big question, okay? I'm gonna answer that question with this slide here, okay? When is it okay to limit or deny the emotional support animal? So if the animal is an actual threat, but not a perceived one, yes. So breed or size is not an actual threat. That's just the breed or size of an animal. So if that particular breed has a reputation of being dangerous, that's stereotyping breeds of animals, okay? That's discrimination against a certain species, okay? Now, if that particular animal itself, okay, that dog, that cat, that alligator has a previous history of unsafe incidents, that's proof of an actual threat. So if it's nipping at people's heels, it is violently barking at people in the hallways, it actually did try to bite someone, all right, now that specific animal is a threat. You might be wondering, well, if I have an emotional support alligator, it's just a matter of time before it's an actual threat. Case law is kind of waiting to come around on that, okay? At what point does it become an actual threat? Because we grew up thinking alligators are dangerous, or because they actually are dangerous? Like, at what point does it cross the line to actual threat versus a perceived one? But for right now, it's case by case basis. So you can deny something once that animal has a history of it. How do you define personal knowledge? Oh, as far as the telehealth and the letter goes, I think it's supposed to be, this is my analogy, and I know it's not a perfect analogy, but if I'm writing a letter for somebody and I'm a licensed practitioner of my healthcare, expert in my healthcare, if I meet with someone long enough to give a proper diagnosis, I have personal knowledge of them. And my analogy is that if I take my car to a mechanic and they review it for 30 minutes and they give me the diagnosis of my car, I'm not going to say, no, you haven't seen my car, 6 times over 5 years. You don't know what you're talking about. I know cars and people are different, but that's kind of my analogy. You are a licensed practitioner in your field of medicine. You have a right to say, I have personal knowledge of this individual after meeting with them. But we are looking at, case law to define, that telehealth interaction. Oops, sorry. When the nexus of the disability is unfounded, you can restrict the emotional support animal, okay? So if the ESA letter does not properly prescribe the ESA to the disability. So again, if you say my person has a disability and that disability is physical, they're in a wheelchair, therefore they need an emotional support animal, the dots weren't connected. Are you in a wheelchair and now you're depressed or suffering panic attacks and therefore you need the emotional support animal? Now we have the dots are connected, okay? So if that letter doesn't properly connect those dots, you might be able to restrict or deny that. And courts are now starting to define necessity as indispensable. That is one thing we're starting to see in case law. The law says that the emotional support animal being prescribed is a necessity for the person to equally enjoy their housing. Some courts are starting to say, is it indispensable? And the way they're using that is that there was a case recently, I forget which state it was, where a little girl had emotional support chickens. It was a necessity for her to have an emotional support animal. But the judge said, is it indispensable if they're not chickens? And the judge said, no, they could be something else. So we're starting to see a little bit of a shift in how it's being defined. And then when the existence and care for the animal is an undue burden on the housing unit, you can restrict something. So if Jane has an emotional support shark that needs a 100-gallon tank installed, the landlord can probably deny that. Okay, that's an undue burden. And so that takes us here to, oh, do we have another question here? Can the landlord put prohibitions on where you can bring your emotional support animal, pool or gym? They're not supposed to, okay? If it's an actual threat to other people, then possibly. If they're actually creating a mess in the common spaces, then yes, you need to pick up after that. And if you're an irresponsible caretaker of your emotional support animal, the landlord can come forward and say, look, you're allowed to have this, but you still have to be responsible in having it. But if I say you can have this large dog, but you can't go to the pool, no, I'm putting terms and conditions on your emotional support animal, and that's not allowed. All right, Christina, I'll let you read this one.
Okay, So let's see. It says Jake the snake. Perry has PTSD and delivers a doctor's note to his property manager seeking approval for having an emotional support animal in his apartment. The doctor he met with was an online therapist with full credentials, whom he has met with twice. The animal he selects is a non-venomous snake, 3 feet in length, and roughly similar in size to his arm, named Jake. The snake reminds him of one similar to the one his cousin had when they were kids, and takes him back to a peaceful part of his life when the snake wraps around his shoulders as he watches TV. The property manager refuses the request, stating that it will make the other tenants uncomfortable and that their pet policy is very strict.
All right, let's light up that
What are
chat
the
room.
issues here?
Let's, issue spot. What do we see? Anything wrong here? And look at it from the lens of the housing provider. Look at it from the lens of everybody. It's not a pet, it's an emotional support animal, correct? So at the very end, when he says we have a very strict pet policy, Perry can say, yeah, and I respect that very strict pet policy. I don't have a pet though. Big problem for the landlord. I mean, yeah, it can be, but as long as Perry is responsible with his snake, it shouldn't be a problem for the landlord. Now, other tenants might complain, but simply not liking snakes is not an actual threat. That's something you have to remember. Some people love dogs, some people love cats, some people love snakes, some people love alligators. Disliking them is not a threat. It's just a preference. Okay, so it's not an actual threat to have a non-venomous snake. How about, is there an actual nexus to his disability? Well, we purposely put in this fact pattern that it takes him to a peaceful place back in his life. You know, that's what an emotional support animal can do. And you have PTSD. Yeah, okay. He found peace with this snake. That's his happy place. If you give Perry a dog, he might not have that happy space. This is about Perry and about Perry's disability. It's not about the, standard understanding of what a pet is, okay? So yeah, okay, I think we tackled this one pretty good. And in the interest of time, I guess we just have a couple minutes, but any questions for us? Chat box, Q&A, and we're really grateful. You guys have been doing a fantastic job asking us questions along the way, but please jump in.
And I was going to say the same. You all are an awesome audience, an awesome group. It's been so much fun to just watch you all tease out these issues. I'm going to mute myself and pull up the CLE while you all are brainstorming any last questions, or if there's anything else you all want to talk about.
Well, I'll just repeat what Alexis said. I know Christina and I, we really enjoy doing these, and I think this is our third one. I believe we have one more next month. And I think we actually do have one in October, but it's not part of this series, but we will be a part of on October. So thank you guys so much for your interaction, your questions, all the good feedback. What if the need for the animal changes during the lease term? Is the tenant required to update the landlord? Yes, okay. I'm glad you brought that up. This is very important as well. Let's say you already have a pet, you already have a dog, and then 6 months into your tenancy, you have like a domestic violence event. You have something that is traumatic in your life. And now you're diagnosed with some sort of mental health, emotional support, emotional health. Your existing pet can become your emotional support animal, okay? As long as you have that doctor's letter that says you need it, you can take it to the landlord and say, I know I already have the dog, but now it's my emotional support animal. So if you guys change the pet policy so that I can't have this anymore, it doesn't apply to me because it's now my emotional support animal. And the reverse can become true as well. If you no longer suffer from that particular disability that it was prescribed, similar to any other medication, the doctor is not going to keep you on medication that you don't need anymore. So if things do change, you are supposed to update the landlord. Does the doctor's letter need to be updated, or is it good for several years? I recommend getting it updated, especially if it's going to come in some sort of denial of housing. It's better to have an updated letter. Have a relationship with your doctor every year, get that thing updated. Does it have to be? No. Should it be? Probably. That's best practices. Where can people go for assistance for housing discrimination cases? All right, right here. I'm putting it on the screen right now. That's us. That's our phone numbers. That's our email address. That's our Facebook website. Please send people our way if you hear these concerns about fair housing and stuff like that. We operate in a specific region in kind of North Central Florida, but if we're not able to reach them, we definitely can. And then there's a question about, is there income limits? Great question. The Fair Housing Act does not have income limits. It applies to all people, okay? So if someone tries to say, sorry, there's income limits. Oh, as far as our service from Florida Legal Services go, no, we operate under the Fair Housing Act, which applies to everybody. No income limits, yes.
Awesome. So I just dropped the CLE code into the chat. Let me go up a little bit. You might need to scroll up to get it. It is 6316. Again, that's 6316. This installment was approved for 1.0 general CLE credit. I also put the information in for our, I don't even want to say it, our final installment of this training series. I don't want it to end on Tuesday, the 27th of September. And that is approved for general and some bias elimination as well. I will include that information of our next training in the follow-up email, along with the CLE code, along with the materials and a copy of this recording. Again, that email will come from Zoom. But if you don't see it, my email is at the top of the chat. Jot that down, and of course, reach out to me directly. So with that, no further questions in the chat or in the Q&A, right? We double checked. Did we answered everything?
I think you just mentioned your. Go ahead.
Oh, I was going to say, sorry, there's a few questions. I was trying to type them in, but if we can answer them live now.
Yeah. Listen, anyone who can't stay, you can drop off. You will get a copy of the recording, and it will include all these questions and answers. Go for it. My time is yours.
It says, what if I was approved for a dog and the dog dies, and now I want to get an alligator as an emotional support animal? Do I have to get a new approval?
Great question. So you don't need new approval for an emotional support animal, but you do need to update the landlord that this is now your emotional support animal. A lot of times people will say, I have this letter that says I need an emotional support animal, and then they like hurry and sneak 7 dogs in. One of those is your emotional support animal. The other 6 are violating the pet policy, okay?
Mm-hmm.
That doesn't necessarily mean the alligator is gonna be denied. It just means that you do have to update them.
And I think I answered it, but one of the questions is, can the landlord limit the amount of emotional support animal you have? I said no.
The landlord cannot, but if the letter doesn't say they need a certain number of them, then the letter is really just for one. So if the doctor says this person will benefit from a family of ducks, then the landlord is supposed to allow for a family of ducks.
Okay.
So yeah, the landlord is not the judge. It's the doctor that says, here's what you need.
Okay, good.
Yeah.
You understood the question better than me then. Thank you. I think we answered them all then. And then, and Alexis, you're going to share the PowerPoint presentations after this. Okay, good.
Farewell.
All right.
You'll get the recording, the PowerPoint. You'll also get the CLE number, so don't worry if you missed it now. And I think that is it for today. I don't want this to end. I always enjoy listening to the both of you. You're a fantastic team. And this is a great subject. And thank you for breaking it down for us. Thank you for making it digestible. And thank you for, making it something that we can all, learn and understand from. And thank you to our audience. You all are awesome. Great participation, great questions. And we look forward to seeing you at the next one on the 27th of September.
Sounds great.
Thank you.
Thank you. Bye, everybody.
Thank you, everyone.
Thank you.
Bye,
Thank you.
everyone.
Bye.